this matter. A covenant deed was entered related to this property back in 2004. In a relevant part, it states the grantors, meaning Arcadis in this particular instance, right of access shall not be interrupted. Going into the release of claims related to this matter. Sorry, I just heard some feedback. I heard myself.
I'm sorry. That was probably my fault. Go ahead. I'm sorry. It won't happen again.
That's okay. Right of access shall not be interrupted by any transfer, assignment, conveyance, mortgage, lease. Moving down further into the release, it says subject to the grantor's obligations in the contract with respect to certain defined quote unquote work, grantee hereby waives and releases grantor, its parents, affiliates, subsidiaries, so on and so forth, from and against any and all claims, demands, damages, costs, and expenses, including attorney's fees, court costs, awards, settlements, judgments, penalties, fines, liens, or cause of action at law or in equity. Moving further into the release, it further states in any other applicable environmental laws, statutes, ordinance, rules, regulations, or orders, quote unquote, laws arising out of or relating to the hydrocarbons and remediation thereof. In this matter, Arcadis became the relevant environmental consultant in August 2009. At that point, a SVE system was installed and it was housed within a shed that's on plaintiff's property. The system was quote unquote decommissioned, not in use, inactive as the reports indicate, beginning in 2004. However, the prior remedial consultant kept it active, kept maintenance up on it because there may be a potential for the equipment to be used again moving forward should any condition in the land change. When Arcadis assumed responsibility for the property, it maintained the status quo under the previous covenant, and thereby too under the previous covenant deed. With that, in their reports to the now known as Eagle, it specifically indicated that although the shed was inactive, or the equipment in the shed was inactive, it still needed to be monitored, and the feasibility of restarting that equipment needed to be evaluated before a closing remedial strategy could be executed. What's particularly relevant to this, or a fact that needs to be taken note of here, is that in order for Arcadis to fully evaluate the situation, a full 2 years has to go by because the sample, that's how long it takes to get a full set of samples. The samples are taken bi-quarterly per year. And in order to account for seasonal differentials or fluctuations, 1 year you have to take it in Q1, Q3, and then the following year, Q2 and Q4. So it has to go a full 2 years for a cycle to be completed for them to evaluate what the remedial plan must be. So at that point, Arcadis kept with the status quo as it was required to in order to do its due diligence and evaluate the necessity of the equipment within the shed and therefore the shed's presence on that property. This is repeated in what's attached to exhibit plaintiff's own response in exhibits exhibits H and I, where Arcadis specifically affirmatively states, we're evaluating the potentially restarting this equipment, and if it's necessary. In 2012, they reported, we're seeing a decline in this property and the environmental risks that it has. We will further evaluate, because as the scientific method dictates, just because you get your results once, you have to do it again to confirm in order to move forward. And so they waited and they did their due diligence, followed another cycle, reported another decline, at which point they recommended in November 2014, that the site could be closed. And that's at that point that Arcadis provided the recommendation to close the site, which requires before closing a restrictive covenant, which was circulated to plaintiff at that time in July 2015 after the fourth quarter 2014 samples were taken. So plaintiff's brief presents this issue as, oh, you knew back in 2004 when you weren't using the equipment that it could be taken out, but that's simply not true. That doesn't provide the full parameters or scope of the work that needs to be done, because this is environmental risk and environments have to be monitored and evaluated over time. Given that the shed was there for Arcadis's monitoring and therefore related to the work that was being done with the environmental remediation, the release in the covenant deed is applicable to any and all claims. It's broad and fully encompassing because that's what the parties intended for this property. Plaintiff does not deny that it's bound by the covenant deed and the restrictions therein. And that interpretation, Your Honor, given the broad language, is justified in this matter. And there's no denying, based on the report submitted attached to both our brief and plaintiff's response, that the release applies and that the monitoring of the site is related to the work for the environmental remediation considered in the release. Moving further into the argument, and besides the release, Your Honor, there are additional reasons as to why plaintiff's individual claims should be dismissed. First and foremost, no statements were ever reiterated or uttered by any employee of Arcadis. The reports specifically state that the site needed to be monitored for the first 2 years and then monitored again to confirm the decline. And then once that decline was confirmed by the results from the 2 cycles, that's when a restrictive covenant could be put in place. That's when they could proceed with the site closure, at which point the shed could be removed. The shed's removal in 2019, as plaintiff would like to point out, although done before the execution of the restrictive covenant, was in an effort to accommodate plaintiff, to buy their peace, quote unquote, because although practically, yes, you can remove the shed, the site's still open, Your Honor. It's still registered as an environmental risk. And at any point in time, EGLE, the relevant state department and authority, the only body in the state with the authority to designate the site as closed and not a risk, has not done as such. So at any point in time, they can come back and say, hey, you have to put the equipment back in, the shed has to go back. And so against their own better judgment, they remove the shed for plaintiff's benefit in an effort to avoid litigation, which unfortunately did not occur in this case. With that, no statements of fraud were ever reiterated or spoken to the plaintiffs here by Arcadis's employees. They've always been fully represented that the shed was ready for removal in 2014, but without plaintiffs' execution of the restrictive covenant, they recommended against as such because the site would remain open. They needed that restrictive covenant to close the site. Going into the interference with the business relationship claim, claims such as those fail if there is a quote unquote legitimate business reason for the actions of the defendant. That is taken from Daly versus Dykema Gossett. The citation is 287 Mish App 296 at page 323 to 324. Based on the previous statements and facts as presented to this court, it's clear that Arcadis had a business reason for not removing the shed. It was part of its monitoring efforts related to the environmental remediation of the property. Because how can you remediate a property if you're not monitoring it, taking the samples, getting the information you need? Having that shed on site was a part of that process because they needed to evaluate if the equipment inside needed to be restarted and if that was a feasible remediation strategy for this property. Given that that exists in this case, the claim will fail as a matter of law. With that, Your Honor, I will allow plaintiff to present a response.
All right, thank you. Mr. Leon?
Yes, thank you very much. But am I to understand then that the the rest of the claims, there's no reply to?
We will stand on our brief in that regard.
Okay.
I know that you filed or proposed an amended answer, but with that, a lot of those claims, the only claim that appears to be new, which we have not fully briefed, and if the court would like a briefing on those issues, we can. In regards, that is true. Thank you for reminding me. In regards to the conversion claim, conversion, Your Honor, as stated, is regarding personal property. There's no case law, there's no statutory law that says real property can be converted. The courts have reviewed the statute plaintiff relies on, 600/2129, and have never interpreted as such to apply to real property when given an opportunity to do so. With that, I would urge the court to stay with the common law interpretation as the courts have had previously, and find too that there is no standing, or I'm sorry, no ability to state a claim of conversion on the quote unquote conversion of real property, because that claim doesn't exist.
I think he might have also been referring to added claim. It was count 7 in their proposed amended complaint for under the leaking underground storage tank statute.
Yes, yeah, we did see that again as the complaint, that applies to the release as well. All claims are barred under the release that's relevant in this matter, which would include this as well. We can further brief that, but as the complaint has not quote unquote been filed, although it's proposed, we can bring a motion regarding that in the future.
All right, thank you. Now, Mr. Lee.
Well, thank you very much, Judge. What the critically important distinction that was either glossed over intentionally or not is the distinction between monitoring, which continues today. See, there's a network of monitoring wells where they're just checking the level of the groundwater. And what we had here was a building and equipment that had the purge and cleaning equipment, that at the beginning of this cleanup, they were purging the groundwater. This is all contained in the reports. So my first point is to make this huge distinction between the need for the equipment that has been removed and they continue to monitor. So it wasn't needed for monitoring. They continue to do that. It was at what point, this whole case is about, at what point was there a duty to acknowledge that, hey, even if we have to return it later, we are the caretakers. We have this, a lot of this, our case turns on there being not just a general duty, but this fiduciary duty, that they can't sit there and do nothing. They came to the site for 15 years, saw that it was a very small operation. If this were a 5-acre scenario, or they were there for 2 or 3 years beyond maybe what they needed the equipment. And again, the equipment I'm talking about is the equipment, the shed and the equipment that they've removed. So clearly they could do it, and it didn't interfere with anything else they have to do. The point is, was there, and I fully admit, if we lose the duty argument, then they can do whatever they want. But what I'll walk through now in an organized fashion is all of these positions that they've said, but you need to keep that in mind. It's critically important that there's still a network. I would say there's 30 or more of these round plates that are throughout the parking lot that they still come and test. And it's been, as all the reports indicate, so many years since they're just checking to see the groundwater level. And the groundwater level is so low, they're not even checking samples anymore for the contamination. But the point simply being, monitoring is different than the active purge and cleaning process, which ended in 2004. So here we go, Your Honor. And I'll point out that hearing these things about 2-year cycles and what have you, these are all things that are not in their reply brief. Their reply brief actually greatly enhances the arguments I'm about to present. And all they say in their reply brief is that the original complaint was deficient and just proclaim that it was not corrected without telling you what in the new complaint, why the new complaint wasn't satisfying their concerns. And the key fact, and the other thing they say in their reply is this key fact that it's still an open site. Your Honor, I don't believe I've appeared on the record before you, but I do believe from 22 years, recently I was with the Attorney General's office doing solely environmental. And I do believe you're familiar with, cleanup sites get very complex. There's times you need equipment there, you don't need equipment. It's what Arcata seems to be saying is, and I don't mean to be flippant, but it's almost like, oh, 15 years, too bad, sorry, we have this language. So regardless of any other facts and circumstances, we can stay there. What, can they go play poker in that little shed? No, it's for a specific purpose. And this is before I get to the law that says, for some reason, Ms. Buford Cameraman didn't seem, to my ears, didn't address, she spent a good deal of time on the covenant deed, but the restrictive covenant language, she didn't seem to touch. I don't know if that was an oversight, but that's what I'm going to walk you through, Your Honor. And that's what they seem to be saying, that regardless of any of the facts and circumstances, which is of course my main emphasis, this whole case, the plaintiff's whole case is about the particular facts and circumstances here at this location. And so what we have is, if you look to the language, the first item up is the restrictive covenant, Your Honor. And this is where her reply brief brings out even, makes my case even stronger. If that happened to be in front of you, the 4-page reply brief, Your Honor.
Yeah, I got it. Is that what you're asking?
Okay, yes. And if you go here, so we agree with everything that's said in this reply brief, except the conclusion. So if you go to what's listed as paragraph 1, well, let me first say, regarding restrictive covenants, I laid out there, I won't go through it, all the very strong law that a restrictive covenant is in disfavor. They're interpreted to minimize, they're interpreted in a way to maximize a landowner's right to use their property. So fine, if there's a restrictive covenant, but there's any ambiguity, any questions about it, I'll leave it to the court to review that case law. I've highlighted all the key passages, I've bolded them, and it goes over and over again how they're always interpreted against the writer, the common contract sort of arguments you hear. But for more than a contract theory, it's the principle of people being able to use the property they own. So with the backdrop of very strong law saying you limit restrictive covenants, obviously you look to the words, but you limit their interpretation if there's any sort of doubt. And when you go to the restrictive covenant, which she quotes, again, if we go to the reply brief that was filed, the number in quotation margins, the number 1 paragraph says, it's therefore, and you'll see the words in the middle line, measures necessary. Okay, we agree with that. They're supposed to, this right to go onto somebody else's property, an innocent party in addition, is to do measures that are necessary. If you go to the next paragraph, in fact, if you go to page 4, flip the page, the very top line, and this is really key, says to be there at reasonable times, okay, for monitoring and compliance. And then the rest of it just says these restrictions continue to apply. We agree the restrictions apply to this day. But the language of the restrictions say, there's a case law, and then the restrictions say, go there, do what you need to do, the reasonable measure, or excuse me, measures necessary, and do it at reasonable times. This is not a carte blanche, hey, as long as there's any conceivable thing you might need to do in the future, you're allowed to occupy this property. So our case is about that there is an additional defendant we would add. We think that they should have brought them in, but so this case is about, and we're still just dealing with the restrictive covenant, is was it reasonable, particularly here for Arcadis, to take over in 2006, excuse me, is it 2009, I believe, 2009. But at the time they had reports from the prior entity that said, we believe that we closed it down. Again, this is the purge and cleaning equipment that you need the shed for. You don't need the shed to do the ongoing monitoring that goes on to today. So when Arcadis takes over, they of course have a duty to look at what the status of the scenario is. And there were reports that not only was the clean and purge equipment turned off in 2004, but they apparently believed it should have been removed in 2006. I won't bore you with taking to that page. It's highlighted repeatedly in the reports that the equipment was removed in 2006. Well, it wasn't, but the important part of it is that the predecessor to Arcadis And therefore Arcadis, with their duty to know what they're doing and knowing the property they're taking over, and a duty to read the prior reports, should have brought up the question, well, wait a minute, if you haven't used it in 2004, it was supposedly, a determination was made to remove it in 2006, and there's some sort of, by accident or whatever, it never physically got done. So Arcadis comes in and even though they're there, the best estimate I have for my clients is about monthly. For one reason or another, someone would come by. They're usually doing the monitoring of these wells, have nothing to do with the building, would come and go often, not go to the building. In fact, at one point, and I don't think it's in these briefs, but and remember too, if I can remind everyone right now, particularly Your Honor, this is before any discovery. So I don't have to prove the case on a preponderance, of course. We're just trying to show that there's the allegations should survive, that they're reasonably informed, and there's not a matter of law as to why we would lose. And I mention that right now because there would be, if we're allowed to get into discovery, I can offer here in open court that you will learn that even at one point, they didn't even have the key. It was locked. They had to cut the lock off. So what we have is a building that was there, not used, and it'd be understandable that if they thought they were closing it down, in 04, the report says, there's a couple of the very early reports that are in the filings that you have that say we're turning it off, but the first couple of years, they say we may need it again. But that's in 04 and 05. In 06, there was an apparent decision to remove, again, the purge and clean equipment and the shed. And then Arcadis takes over in 09, and yes, they just continue ignoring, as apparently the legal position is now, they can ignore all facts and circumstances, even though they're a sophisticated agency. These aren't people coming up to clean up the leaves. These are highly technical people coming. They can see that it's a small lot. They know that they should pay some attention because, again, they have this fiduciary duty. They're the only ones in a position. Eagle isn't in a position, and certainly my clients aren't in a position to know, is this equipment still needed? So that's the restrictive covenant, Your Honor. We agree it's still in place. We agree it applies. We disagree that language that says, take the measures that are not, this is the permission that they have. And again, I know I'm beating it up, Your Honor, but I think you'll see why when there's it's reviewed again, the case law about how to interpret a restrictive covenant. And so when the covenant, the special permission to go onto their active business property says, take the measures that are necessary, do it at reasonable times, that, and you add to that what I think is their fiduciary duty, even just a standard duty, but a fiduciary duty given their unique relationship of being the only ones in a position to know whether this equipment is needed or not. And they had reports indicating that maybe it wasn't needed. So that's the restrictive covenant. And we believe that, again, that argument was set out in my brief, in my reply to their motion, and my response to their motion. The reply just, apparently they're just sitting on the argument, Your Honor, we have this language in restrictive covenant and in release, and none of these other factors matter. So now to move to the, covered all that, Your Honor. Now we go to the covenant deed. And again, the language is, we agree the covenant deed is still in effect. But what we have here, Your Honor, is strictly there's facts that just aren't known yet. The covenant deed itself says that Arcadis's duties are subject to a contract, which no one has seen, we haven't seen yet, and by quote unquote work that's somehow described. So until we know, that could affect things. It could affect things that don't help my client's case, but we don't know what is. There's apparently further detailed description of what Arcadis's, well, what the environmental entity's duties were. And yes, they are released. The release language that is broad, but it's typically broad from any and all claims whatsoever that have to do relating to the hydrocarbons. Okay, and our position is this, Your Honor. The hydrocarbons are simply the chemical contaminants. And our position is at some point, just because there's equipment there that could help with hydrocarbon cleanup, all that's going on for 15 years is monitoring. And they don't have a right to continue to take up extremely valuable space. If you were to go, Your Honor, if you had the chance, if you go to plaintiff's filing and you go to Exhibit D, the last page is a photo, color photo that gives you a great understanding of what we're talking about here. You can see the shed to the right of the main building. And the white car, if you're able to see this, Your Honor, it can only be, if you see the cars that are closer to the bottom of the page, you'll see where the direction they're pointing. With that shed there, there's just valuable space. And hopefully we'll survive this motion, Your Honor, and the experts will come in and you'll have to hear arguments about how much it affected the business. But the point is, I've thoroughly covered the restrictive covenant. We're talking now the covenant deed. And yes, they're completely protected from any and all claims, except if it's completely unreasonable. And everyone knows that. There you can have a release, but the release doesn't mean, it only releases them from their legitimate work relating to the cleanup. And again, I'll keep coming and saying a lot of these things over again because it's the same facts that defeat all their arguments, is that it's not the release language is not a carte blanche to just do whatever you want on the property. And there came a point when again, if we get past this stage and we're allowed to get into discovery and maybe even expert testimony, I believe the argument was that you just heard was that, I'll read it 1 second here. There was a phrase that was used that they had to evaluate. I'm not saying, but the point still being that there's a point in time when that equipment, the purge and clean equipment, no, it is not related to hydrocarbon cleanup anymore. Not under any reasonable understanding of the relationship between the need for that equipment to be there. And again, I believe Your Honor is familiar with these sort of scenarios. So their opinion is no matter what we do, we could be, and I'm sorry for the parent flippantness, but play poker, you could just leave that there. You could decide to store other equipment in there. And as a matter of fact, if we get into discovery, there will be testimony that at one time, in fact, I believe I saw it myself, that at one point, someone wanted to come to check to see if a certain piece of equipment was in the shed, not to use it at the site. So what we have, I don't know how much was by design, how much was just oversight, Your Honor, a big international company taking over this site. And I don't know how thoroughly they read the prior reports, but they took over the location, never have used that equipment, got rid of it in a flash. I'll get to the fraud claims. As soon as a lawyer was involved, they seemed to have no problem taking it out of there. So that, sorry, I've strayed a little from the covenant deed and the release language. And just because it says any and all claims, it doesn't include acting beyond your duty of any reasonable, of what the relationship is. So no, at a time when it hadn't been used for, I don't know if it's the 2-year point, but certainly by 5 years, when reports that it hasn't been used since 2004, it was intended to be removed in 2006. Somewhere in there, a few years later, it's not related to the cleanup. It is not needed. They don't get to leave it there for 15 or who knows, we could have 5 or 10 more years, because the actual closure of the site that's being mentioned has to do with all sorts of other little details. It could even come down to whether they paint the curbs right in the end to close the site out. So I believe that's all I have. Obviously, if there's any questions, all I have on that. When we get to the fraud, Your Honor, I won't go through quoting the letters, but you can see that when my clients, there's emails that are in the exhibits where I'm going to say starting in, it might have even been 2010 is the first exchanges, but we have, and again, discovery would be needed to get into this, but we have Elizabeth Olsen is her name, an employee there, which, let me interject this too. Part of the reply, it has to do with this issue. One phrase in the reply was that our original complaint was severely deficient, is the phrase. Well, it was on purpose with regard to fraud. And I could produce the email. It was stated when this was served shortly after that, listen, we purposely don't want to name an individual and go after an individual. So we're purposely leaving that vague, hoping that maybe we could talk this out. So I just want to point that out. But since they've chose no, there was, they chose not to talk options at that point. So now we have a complaint on the fraud that, again, we're at the stage of, we're not at the stage of me proving my case to ultimately win it on a preponderance of evidence. We're just saying, is there any, this is where the discovery rules are quite clear of the case law, that only if discovery could not possibly produce the potential for liability, do you dismiss fraud claims now? And the emails are there, Your Honor, where for years, at a minimum starting in 2014, and it might go to 2010, where there was the first exchanges of my client saying, hey, when can you get rid of this thing? And they're being told, hey, why don't you go, I'll just give this one example that's in there. Hey, OK Auto, this is coming directly, an email from Elizabeth Olson, thank you, to my client, to my left here, saying, hey, could you go get estimates on what it would be to do the blacktop work and repair it? And then when he does, which of course is not his duty at all to do that work for them. And then when these men are busy every day hustling cars, if I may put it that way. I mean, it's not like sitting around and they're checking the market all day. They are hustling, making calls, moving cars. So when Mr. Sabet, my client here, makes a contact, and he even got one estimate, there's an email back, well, corporate or some, my bosses would really like 3 estimates. None of this is required. My position is that Ms. Olson, again, I have no idea what was in her mind as far as it being a strategy or just maybe she thought it was okay. The point is, there was talk about removing it, going back to, again, a minimum 2014, but certainly, but possibly back to 2010 in these emails that, yeah, I'm working on getting rid of it. This is Arcadis talking, but could you do this? Could you do that? Hey, what do you think of the latest covenant language? None of that, but still not getting it done. But sure enough, within 42 days of them getting a letter from me, Your Honor, it's gone. So, and the reason that that's important, it shows that yes, they also did it to maybe satisfy us, but it's not needed for the work they're doing there. The only question I submit to you, Your Honor, is when is a reasonable date to say that this sophisticated environmental engineers coming there all the time, seeing the situation they're working with, when was they had a duty to say, we can pull this thing out of here. And again, I'm gonna pound on it again. They stopped using it in 2004. They thought they were removing it in 2006. So if we're looking for when their experts, if you will, Your Honor, thought it should be removed, it's 2006. And when Arcadis, the current sole defendant here right now, they have a duty to know what the prior entity, which the mother entity is Atnia or something, but we'll call them Delta Environmental. That was their operating name. So they had, when 09 comes and Arcadis takes over, of course they have a duty to understand the site. They should have read this, that boy, if the equipment they thought it was removed in 06, it should have been removed. So the fraud, dead on the fraud, Your Honor, really all I need to prevail for today's proceedings on fraud is there's more discovery. Certainly, unless this court rules that there is no conceivable facts that could be discovered that would help support a fraud claim. As far as interference with business, this will be really quick, Your Honor. Their motion says it was deficient of sufficient facts. We claim that no, it wasn't, but I'll tell you what, the amended complaint goes into gives them further detail. And again, you'll see repeatedly in my motion that I say they're conflating, again, by accident or not, they're conflating the standard for just giving a notice, the notice pleading, a reasonable basis to understand the claims that are against them, with the duty to actually prevail on the claim. So for interference with business, certainly, again, nothing in their written reply explaining why any of our amended complaint is deficient, just the proclamation that our corrections were to no avail. So interference with business, again, unless you determine that there's no discovery that could possibly support that claim. And that is the language I was looking for. On the count of interference with business, it was as long as they were doing something legitimate, they had a legitimate business purpose. So again, I don't have to win the whole case today, I believe. I just have to show that discovery could support this claim. But our position will be that really when they took the site over in 2009, starting from then, there was no legitimate business purpose for, again, the purge and clean equipment and shed to be there. So then moving on to, we're almost there. There was an unjust enrichment claim that has been dropped. It was just be duplicative, and but anyway, that's been dropped from. It does not appear in the amended complaint. As far as that statutory claim, I would again suggest to you that that the same things apply. Certainly, the catch with that claim is there's unknown facts. That statute says that if by court order, I'm paraphrasing, but I'm very close, Your Honor. If it's a court order, a court-ordered covenant that allowed them to be on the property, because I believe, as this court knows, there are people who have said, no, I don't care, you got to do a cleanup. You can't come on my property. This is the law that says, well, an entity that's, the responsible party, the PRP, can go into a court and say, Your Honor, we need to go on involuntarily onto this person's property. And the statute says that if by court order, there is a covenant deed, or if there's any sort of restrictions that allow them to go on the property, that the property owner is due damages, including lost income, et cetera. So we won't know, quite frankly, if discovery is needed to see if that claim can survive. On the treble damages, which again, I would say, Your Honor, it's just moot right now. It's a damage. I mean, we don't have to argue about what damages are allowable, but we fully admit that that it appears to be a case of first impression. The very short version is this: no question about it. Common law for eons has been that to convert property, conversion is only a personal property. But there's a history that's laid out there where it started to get broadened. And there was a statute, the statute that's at issue here, that says, by the way, it's not just about conversion. It says you get treble damages if you embezzle or steal, are the words, or convert property. And while there's been a series of cases, it's been understandably pointed out, this language has been looked at, and there's never been anything that said, oh, hey, this appears to go beyond personal property. However, they didn't address it at all. They were addressing other aspects of the statute. No one has ever said, hey, wait a minute, even though this was passed, boy, it is a couple decades ago, this statute is not new. But no one has ever said, let me back up one half step. There is a key decision that says the purpose of the statute was to broaden its reach. Because the way it was originally written, you couldn't even go against the person. It was only, they were going after fencers. So if I'm the person that stole something and I gave it to you, and you're the one that sold it, they were going after that person. The statute came in to broaden it to include the actual person who stole the property. And it added the words to, again, it's not a conversion statute, it's a treble damages statute. So if you steal, you embezzle, undefined, so there's that, or you convert quote unquote property. So no court has looked at this and said, they broadened it for some reasons. And the cases that came before the courts were for specific other language. But apparently no court has said, even though they use the word property. And what I've included is Black Law Dictionary from that period of time, from 1968, that it just happened to be on my shelf. Luckily, it was from a time period that would be the definitions that legislature, I think it was 75, I'm sorry, I apologize if that's not immediately in front of me. And not only does the word property include real property, it emphasizes that it includes real property. And you'll see that, it's an exhibit. I put the Black's Law Dictionary samples in my exhibits. So again, damages are just not ripe to discuss yet. But if the court thinks that maybe it should rule now on that, we would ask that that it is a legitimate argument, as you know, to extend, existing law, which I would agree, common law. But the common law doesn't matter here. Oh, well, the common law is a secondary factor. There's a statute we're dealing with that built upon common law. And I'm just saying, no court has ever examined whether it included property. And there's plenty of cases that I hope to get to in future briefing, that the logic of extending it beyond real property is there. There is no reason someone, just because what their loss was, had to do with real estate. I mean, you can steal, you can embezzle, or you can convert, all sorts of things. And so there's no real logic to say, oh, but it's, sorry, you get to get ripped off because it happened to be real estate. Your Honor, if I can have just 1 second, but I believe that is primarily what I wanted to bring to you. If the court decides that some, if not all, of the amended complaint survives and can be served, I would be asking, and I don't know if it's in my request for relief, I've never actually ran into this, and of course there'd have to be some new summons. I know that is a housekeeping matter. That's my problem. The only other thing I'd mention is there are several places in my briefing where the errata is minor, but I've said several times, and if someone was getting into the details, I don't want to get them confused, where I say that Arcadis took over in 06, or they should have known this in 06. And the errata there is it should have been, no, they took over in 09. They should have known about the reports that dated to 06. And that's about all. If I can have 1 second, Your Honor, just to review to see if I have anything more. I will end with, again, the broad picture. We have a 15-year period during which equipment that was there, that by to my take, any reasonable review of this record shows that the prior environmental firm to Arcadis had determined this stuff can go. In fact, they apparently believed they had removed it. And so if Arcadis is coming in saying, no, Judge, just look at the language and we've got a release, we've got a restrictive covenant, none of the other factors matter. And then one last item, because so much could turn on it, and that's the difference between just a general duty and the fiduciary duty. The law is all laid out. Obviously, there's fiduciary duties that we're all very familiar with, attorneys, doctors, but the law is very clear. Fiduciary duties are created when there's one entity that has the advantage, the unique information and power over a scenario that controls other people's interests. That's exactly what we have here, Your Honor. All Arcadis had to do was really care enough. And to put a little kind of twist on it at the end, and then I'm done, is when my clients really started saying, they bought you see their affidavit in there, Your Honor, they bought it, fully understanding that it was there, but an understanding, they didn't read every detail, didn't need to, they understood when, it'll be taken away when it's supposed to be taken away. And what we have here is Arcadis, I'm repeating myself, so I know I should stop. Arcadis' position, Your Honor, is doesn't matter. Nothing else matters. We got this language here. It doesn't matter what we were doing with it, when it was needed. And I guess to try to stop myself from talking, Your Honor, you might need nothing further regarding the arguments we heard from fellow counsel here, that the monitoring still goes on. So a key thing, it's good to end where I started. The critical distinction between monitoring, which still goes on, and the active purge and clean is what this case is about. And long ago, the purge and clean equipment and shed should have been taken off. Even if, I guess this is how I'll finish, it is true it might get called back. I still submit, it doesn't mean you get to leave it there for 15 years. 2 years, 3 years, still waiting to see if you need it, 5 years, that's one thing, Your Honor. The only question in my mind, in this case, in my mind, is when do we start calculating the damages? At what year here was it just inexplicable to say that Arcadis could ignore all the facts that they see every month when they come to the site and leave the equipment there? Thank you, Your Honor.
Thank you. Ms. Buford Cameraman?
Yes, Your Honor. A few brief points in closing. First and foremost, even if you look at, specifically, when you look at Plaintiff's Exhibit H, Your Honor, this is the March 2010 report submitted by Arcadis. And it states towards the end of the first paragraph that Delta, the prior remediation expert, or Arcadis's predecessor, had actually maintained and operated or reviewed the SVE as needed all the way up until April 2008. Arcadis was informed by the reports, as noted in their own findings and reporting to Eagle, that this equipment was on the property. The prior evaluator thought it might still be necessary, and they kept it and they maintained that equipment. They kept it functioning and operating.
I don't want to accept, I'm sorry, could you point to me where you're?
Yes.
So H, but sorry for interrupting, but I want to see what you're talking about.
First page, there's that paragraph, and then 1, 2, 3, 4 lines up. I found it easier in your exhibit. Let me go back here.
H.
Yes, H. You also see it in Exhibit F from your 2012 report attached to your brief. On page 3 of 7, there's the first paragraph.
Yes.
You go 3 lines at the bottom of the first paragraph, and it says, in addition, operation and maintenance activities were performed on the SVE system from October 2006 through April 2008 as necessary. Therefore, Your Honor, this indicates that the SVE system, Delta, the prior predecessor to Arcadis, found that they needed to keep the equipment ready. And when Arcadis assumed the project and assumed the responsibility for it, they said, okay, we're going to evaluate if this equipment is necessary. And they restarted it in April 2010 to make that assessment. They then, as stated previously, completed the first 2 cycles of the monitoring. And when they finally determined in 2014, that's only 4 years from when they assumed the project, not this 15-year span that plaintiffs asserting. Arcadis was not negligent, even if, and this is not to say that a fiduciary duty applies, we don't believe it does, but assume arguendo that if it did, it's fulfilled its duty to do so, because when they assumed it, they evaluated the equipment. They completed their proper evaluation of testing and monitoring for 2 years and confirming those results in the 2012 to 2014 cycle. And then finally, they reported in their first report after those secondary results came in that the site could be closed. But the first step in that process of closing the site, in order to ensure that, you know, if the shed's taken away, if the equipment's taken away, we don't have to come back and redo it, and being prudent in their statements and findings. First quarter step that needs to be taken, the next step that needs to be taken is a restrictive covenant. It's listed as a step that needed to be taken immediately following. And they initiated as such, as shown by the correspondence in the 2014 correspondence. A week later, they said, we're starting to evaluate the removal of the shed. There's no unreasonable delay on Arcadis's part, as asserted by plaintiff. With that, Your Honor, that goes to the point that these actions by Arcadis in the relevant time are related to the hydrocarbon remediation on the property. And with that, Your Honor, we would assert that the claim applies, and we don't want to belabor the point too much, but we'd also note that conversion under the trouble damages statute, which was enacted 30 years ago, Your Honor, courts have had an opportunity to say that this applies to real property. They've had 30 years to do so, and there's no cases indicating that they've ever held as such, which indicates that this statute is intended to follow or reinforce the common law cause of action of conversion. And that common law action does not apply to real property. And with that, Your Honor, we would respectfully request that this court grant Arcadis's motion.
All right, thank you.
Thank you.
As I said at the beginning, this is Arcadis's motion, and they are asking for dismissal of the complaint in its entirety. I'll just start with an issue. It wasn't really discussed much in argument today, but it was briefed, and I'll briefly address it, and that is the issue of standing. The defendant raised the issue of standing in this motion. The plaintiff is a lessee of the property in question and not an owner of the property. However, as a tenant, the plaintiff does have a possessory interest in the property, and the plaintiff enjoys exclusive use or occupation of it for all purposes, not prohibited by the terms of the lease. Following the Lansing Schools Education Association case, a litigant has standing if the litigant has a special injury or right or substantial interest that will be detrimentally affected in a manner different from the citizenry at large. And I believe that plaintiff satisfies that standard and does have standing in this case. Turning now to the other issues that are brought by the defendant. There is, as has been discussed, a restrictive covenant. It allows the Department of Environmental Quality, which isn't called that anymore, and I'll just call them the department, and its designated representatives the right to enter the property at reasonable times for the purpose of determining and monitoring compliance with the corrective action plan, including but not limited to the right to take samples, inspect the operation of the corrective action measures, and inspect records. And then the restrictive covenant also says that it shall run with the land and be binding to the title holders, successors, assigns, and lessees, or their authorized agents, employees, or persons acting under their direct control. And then finally, the pertinent provision is that these restrictions shall apply until the department determines that regulated substances no longer present an unacceptable risk to the public health, safety, or welfare, or to the environment. So as we've heard, the plaintiff acknowledges that there is a restrictive covenant that runs with the land, but the plaintiff addresses the restrictive covenant directly with, I would boil it down to 3 arguments, according to the briefing anyway. And one is citation to law that says enforcing a restriction beyond the restrictor's intent deprives the landowner of the right to legal use of his own property. Well, plaintiff isn't a landowner, but plaintiff does have a possessory interest, as I've discussed under the standing argument. But there really is no convincing further argument or analysis as to how the placement of the shed is a restriction beyond the restrictor's intent. In fact, if we're just looking at the restrictive covenant, the restrictor's intent is that the restrictions apply to allow the department to monitor compliance and until, and this is essential, until the department determines that regulated substances no longer present an unacceptable risk to public health, safety, or welfare, or to the environment. There's no basis upon which to conclude that there's any restriction being enforced that's beyond the restrictor's intent, as that's stated in the restrictive covenant. The plaintiff has also argued, and this is a quote from the brief, the state agency's reliance upon and failure to object to Arcadis's report that the groundwater recovery portion of the system was removed in 2006 all but certifies that the state agency accepted that there was no longer an unacceptable risk to the public health and safety, welfare, or to the environment, end quote. There is no legal or factual support for the argument that the state agency somehow implicitly signed off on the restrictive covenant and determined that there was no longer an unacceptable risk to the public or to the environment. Throughout this argument, in the briefing and today, the plaintiff seems to want to separate out, plaintiff does separate out the shed and the groundwater recovery system and all the other remaining parts of the system. But there's no support for that or reason for doing that. The restrictive covenant grants broad rights to the department to monitor, inspect, and sample the property. And the restrictions continue to apply until there's no longer an unacceptable risk. The restrictive covenant doesn't say that a groundwater recovery system may be placed until the groundwater recovery system is no longer used, or that purging may take place until purging is no longer necessary, or that a shed may be placed until a shed is no longer needed. That's not the language of the restrictive covenant. Again, the restrictive covenant is broad and all-inclusive in that the department may monitor and test and etc. until the department says that there's no longer a unacceptable risk. So the department, and I would add as well that as evidenced in the defendant's exhibits 1 and 2, there was activity going on long past the dates that the plaintiff complains about at the property that fall under the broad language of the restrictive covenant. There was soil boring and monitoring that continued on the site long past the time that the groundwater recovery system stopped functioning. It appears through at least December of 2011, if not longer, from the reports that were prepared again and attached to the defendant's brief. But again, I can't distinguish from the language of the restrictive covenant purging from monitoring or the SVE system from anything else, and that's not what the language supports. So the department not only didn't implicitly sign off on the site, but it continued to sample and monitor the site, again, long after the time that the plaintiff complains of that the shed should have been removed. The third argument is that the plaintiff says the defendant owes a fiduciary duty to the plaintiff to execute the terms of the restrictive covenant and to comply with its limits. The plaintiff's argument that a fiduciary duty exists is that Arcadis was the only entity with the unique knowledge of the on-site equipment needs of the activity there at the property. I believe that finding a fiduciary duty exists in that circumstance is unsupported by the facts or by the law. Other than its assertion that there is a fiduciary duty, plaintiff really doesn't support that a fiduciary duty could ever exist in this context, which, remember, this is the context of a commercial relationship where the plaintiff leases commercial property with restrictions that are recorded in a restrictive covenant and known environmental conditions. These are recorded not only in the restrictive covenant, but in the covenant deed between Amico and Paradise Motors, which are all recorded public documents that set forth the history of the property and the environmental issues with the property. So I have to reject as well that there's any fiduciary duty here under these circumstances. The plaintiff makes no argument that could successfully circumvent the restrictive covenant that runs with the land and allows for the presence of monitoring, inspection, and sampling at the property unless and until the department determines that it's no longer needed. And the entire complaint is really premised on the shed and the removal of the shed. And the plaintiffs claim that it should have been removed earlier and that its presence interfered with the plaintiff's business is, in my view, precluded again by the restrictive covenant. And particularly, again, because there's no basis in the language of the restrictive covenant for separating out the shed as separate from the overall monitoring, inspection, and sampling operation at the property. There's also another reason why the claims fail, and that is the matter of a release. And under the release that was granted in this case, Amico and its successors were released from any and all claims arising out of or relating to the hydrocarbons and or the remediation thereof. That is broad and all-inclusive language. And again, I don't think supports separating out, well, if there's a claim about a shed that was part of the hydrocarbon and or remediation activity, is that not covered in the release? There's no basis for doing that. So for all of those reasons, I believe that the complaint in this case cannot succeed as a matter of law. And again, the wording of the restrictive covenant. I don't think there's any basis for proceeding on with the analysis of the fraud claims, again, covered by the release and covered by the restrictive covenant as well. Interference with a business relationship and expectancy, that is required to have been done improperly for that kind of a claim or without justification. That could never be cured because, again, of the language of the restrictive covenant and the covenant deed, which both allowed for this activity to be taking place on the premises. Conversion as well, covered by release and the restrictive covenant. But it also has been argued by the plaintiff that the court should extend conversion to real property, and there's no binding authority for doing that, and I would decline to do that. The Aroma Wines case supports that it applies to personal property. And there is also a claim, and this might have been a new one in the proposed first amended complaint, for negligence and breach of contract. Again, covered already by the remarks that I've made. But even if aside from those, the plaintiff is claiming that it is a third-party beneficiary under the terms of the restrictive covenant. A person is a third-party beneficiary only when the contract establishes that a promise has been made directly to or for the third party. So that claim, even in spite of the release and the restrictive covenant, that claim could never succeed. And then also there was the claim for damages under the leaking underground storage tank statute. For the same reasons I've already given, that claim cannot succeed, but is, as a matter of law, that isn't even applicable here. That statute provides that a person who is liable may, but in this case has not, file a petition seeking access to the property to conduct corrective action. And it's only in that context that the operator of the property may seek compensation. Plaintiff is requesting damages in an action that's never been filed under that section of the statute. So for all of those reasons, the defendant's motion for summary disposition is granted, and that's under MCR 2.116 C7, C8, and C10. In that there is no, to the extent that the plaintiff has argued factual development given the basis upon which I've just ruled, there is no factual development that could alter the language of the restrictive covenant or the covenant deed or the release. And for those reasons, I'm granting the defendant's motion. And Ms. Buford Kammerman, if you would like to prepare an order under the 7-day rule and submit that.
Oh, I apologize, Your Honor.
The circuit court is taking filings by email. We don't officially have a e-filing system up and running as the state is all moving to, but we have a temporary email. It's circuit court records at ingham.org. And you can submit any filings under that.
Wonderful.
Your Honor, just two things. On the 7-day order, we might be able to save that if the parties can simply agree to language. Your ruling's rather clear. I mean, because unless I would ask her to simply run it by me first. So there might be some small language that rather than file objections.
Well, I'll leave it to you two.
Okay.
All the order has to say is for the reasons stated on the record.
And with regard to that, Your Honor, there's the only thing that I wanted to clear up, so that your ruling is that for all of the claims, including and I think you've made this clear, but I just want the record clear that for all of the claims that are in the amended complaint, you are saying there's no factual development, including fiduciary duty in particular. In your judgment today, there's no factual development that would have changed any of your rulings.
That is correct. I worked off the first amended complaint on the assumption that you would be able to file that.
Okay.
All right. Thank you, everyone.
Thank you, Your Honor.
Thank you. Thank you.
Stay safe, everybody.
All right. See you.